Bob, can I come to you first, if I may? I found it, as a medically trained professional, I found this so harrowing to watch. I was moved to tears by it. It was just truly awful. And the words from the judge, it was premeditated, it was calculated, it was cunning, it was cruel, calculated, cynical. She is a child murderer. It is... words fail me, actually. And the fact is that she was able not to appear there for the sentencing. And there are people around this country who are furious that she was not there to look the parents in the eye when she was being sentenced.
You can understand that. It's despicable and it's cowardly and it's offensive, of course, to people. The good news is that justice was properly done, and because of that terrible nature of the offence, she'll die in prison. And I think most people say that is the right result. The one issue that we have to be careful with, though, and I understand the real public concern about people refusing to face the consequences, is that we don't want to set up a situation where, in effect, the murderer becomes the centre of attention at the sentencing hearing. And that's my one concern as to how we proceed. I understand the concept that we don't want people being able to hide in their cells, but equally, we don't want a situation, as could easily occur, and I've dealt with a few murder cases over the years when I was a barrister before I came into Parliament, where someone who is arrogant and controlling, that's very often the way of the people that commit these types of terrible offences, then seeks to interrupt the proceedings. Would it help the parents if there were torrents of abuse coming from the dock whilst the victim impact statements were being read out, whilst there was disturbance? A bit of that happened in the case of the murderers of Fusilier League Rigby. Yeah. And of course, ultimately, it's the judge who has to have control of the court. Indeed, we can give the judge various tools, but it must be in the judge's discretion. And normally what the judge does then is actually send them to the cells. So the irony is that if they created a disturbance, they get what they wanted. So I think we just have to be careful about how we go about this.
I understand that, but equally, I think the Prime Minister can sense that actually there is a shift in public opinion here, that actually the vast majority of the public think this is wrong. The judge was very clear that she should be made to read the impact statements and dwell on the sentencing, and that is only right and proper. And under the current law, I think the prison officers feel they don't have enough security and support to actually bring the prisoner for the sentencing. Would you welcome a change in the law?
I think we need certainly to look at the law and the way it works. I think we do have to talk to the Prison Officers Association, their representatives, about the practicalities of this, though, because, again, it's possible to bring someone at the moment to court and she was in the holding cell underneath. It might well be possible with technology to make sure that the sentencing remarks were beamed into their cell and that they couldn't avoid hearing them. That said, I still have some misgivings about asking prison officers to take what might be, maybe not in the case of Lucy Letby, but if you've got some really substantial, physically large individual with a history of serious violence, we might then be asking prison officers to take risk of some serious injury themselves. So it's getting that balance right. So that's why I'm saying the government are right to look again. But I think we do have to proceed with some care in this, just for fear that we do not create unintended consequences. We all want the same objective. And ultimately, the objective is that this woman's never going to be let out. We all want the families to have some sense of closure. Absolutely. But I would just be wary of politicians promising immediate action on something which may not be so easily delivered, because that wouldn't be fair on the families either.
Of course. And just to bring in Joshua Rozenberg here, should the guilty party be forced to attend sentencing, or should it be up to the victims or the victims' families to decide whether or not they actually want to face the perpetrator in court?
It should certainly be up to the judge to decide. The judge is in control of the court, and the judge must do what is appropriate. The judge has the discretion to run the trial. Clearly, the fact that people now give victim impact statements, something that's only been around for the last 20 or 30 years, is a way in which the trial process recognises that victims and their families are more than just witnesses, but are deeply affected by what happens. And that's certainly an important thing, although it's equally true that nothing that the victims' families said this morning could affect the outcome, which was inevitable, whatever they had said. But Sir Bob Neill is absolutely right about the practicalities. Do you really want to drag a defendant kicking and screaming into the dock? Do you want that person not just handcuffed, but shackled to the floor to stop them moving around? How can you prevent them from turning round to not look at the judge and the family? How can you prevent them closing their eyes? All right, if they're handcuffed, they can't stick their fingers in their ears. But how can you prevent them if they choose to disrupt the court? And also, the other point about the prison officers is that these days you might have a dock officer who doesn't work for the prison service, works for a security company. We've seen your sketches show that many of these dock officers, security officers, are women. They may be slightly built, dealing perhaps with a large offender, as Sir Bob Neill says. The practicalities and the desirability of this need some careful thought.
Absolutely.